Breaking U.S. immigration news. April 2025 begins with a wave of significant developments, especially in the courts. Key legal victories and policy changes are making headlines, particularly for Venezuelan migrants, parole program participants, and individuals facing visa scrutiny. If these topics affect you or someone you know, be sure to watch through to the end for all the latest. Like, subscribe, and turn on the notification bell so you don't miss any updates. One of the most impactful updates comes from the U.S. Court of Appeals, which issued a major decision involving Venezuelan asylum seekers and the long-standing Alien Enemies Act of 1798. Initially heard by Judge Boberg in District Court, the case challenged the mass removal of Venezuelans under this controversial law. The appellate court upheld Boberg's ruling, agreeing that the removals were unlawful. This was especially notable because the three-judge panel included bipartisan appointments, 2 by Republican presidents and 1 by a Democrat. Their ruling clearly stated that an invasion is a military act, not a migrant act, rejecting the administration's efforts to equate mass migration with wartime threats. The court emphasized that due process must be preserved and that the Alien Enemies Act, originally intended for actual wartime scenarios, cannot be broadly applied to modern asylum cases. However, not all judges agreed. One dissented, raising a jurisdictional issue, arguing that the original court may not have had authority to hear the case because it was filed as a habeas corpus petition outside the district where the migrants were detained. Since they were held in Texas, that question of jurisdiction will now return to the lower courts for further review. While this legal battle continues, the administration is also taking aim at key humanitarian parole programs. These include family reunification parole, which allows relatives of petitioners to wait inside the U.S., Uniting for Ukraine, designed for those fleeing the war in Ukraine, and specialized parole for individuals from Venezuela, Haiti, Cuba, and Nicaragua, all intended to offer temporary safety to people from unstable or dangerous regions. These programs are increasingly under legal scrutiny and political pressure. Another troubling development involves the use of immigration authority to revoke visas and even green cards based on political expression. Students and lawful residents participating in protests have reportedly been targeted for removal under the Alien Enemies Act and claims of foreign policy violations. These actions raise serious concerns about the use of immigration law to suppress political dissent. Meanwhile, a new policy shift from U.S. Citizenship and Immigration Services has drawn sharp attention. Effective April 2, 2025, USCIS will recognize only 2 biological sexes, male and female, for the purpose of immigration benefit applications. According to Tricia McLachlan, Assistant Secretary for Public Affairs at the Department of Homeland Security, the policy aligns with what she described as President Trump's revolution of common sense and aims to ensure federal policy matches biological reality. Under this rule, a person's sex must match the designation on the birth certificate issued at or closest to the time of birth. If that certificate doesn't clearly state male or female, USCIS will determine the sex based on secondary evidence. This update applies to all pending and future applications filed on or after April 2. While USCIS said it will not deny benefits solely because an applicant doesn't mark a sex or marks a sex that differs from what's listed on their birth certificate, it clarified that documents with a blank or mismatched sex field will not be issued. Applicants